Well, welcome back to the Law and Crime Network. My name is Bob Bianchi, and I'm going to be taking it from 12 to 3. We got a lot of exciting stuff in this block. But first, I want to bring on my guest right away, my hashtag 4041. Awesome trial lawyer, close to 3 decades at the Department of Justice, over 1,000 prosecutors trained, does criminal defense work, a prolific trial career, and his own radio show. Gene Rossi, welcome back.
Good morning. Good morning. Good afternoon. I'm sorry.
Good afternoon. Yeah, so listen, Gene, we're just right off the get-go. This Kevin Spacey arraignment, this case in general, we're going to show some clips in a little while from that, but what are your general thoughts about what you saw in that courtroom?
On the Kevin Spacey matter?
Right.
I didn't see that, but I will say this. Whenever you have charges where you have not just the person who's the victim in the charge against you, but you have other allegations, he has 20 to 30 other allegations. What could happen if he goes to trial, looks like he may go to trial, is, as you know, those other allegations may come in, even though they're not charged, as what they call 404B other crimes evidence to show motive, plan, opportunity, intent. So that's the biggest hurdle for Kevin Spacey. It's not just that one victim in the charging document in Massachusetts. It could be 20 to 30 others.
Well, I was just recently asked on that very point, Gene, let's go to the Cosby factor. So they get a mistrial in the first case. That 404 evidence that you referred to is typically not to include other acts or other prior or after acts of bad character, because they don't want to be a trial by character assassination. But as you, of course, aptly cited the rule, there are exceptions to it. And in Cosby, they originally indicated, I think there was like 5 other things or a couple that they were allowed to use, and then they allowed in the second trial a lot more. And people, legal scholars like yourself, believe that that was the tipping point for them, and that's what you're bringing up could occur in the Spacey case. And you know, when I first started my career, Gene Rossi, the judges were very, very circumspect about allowing 404 evidence to come in, because it's like multiple trials within trials. They called it trial by ambush. But I agree with you. The facts may seem a little weak on Spacey if just that young man testifies, but if you add to it a plethora of other complaints, doesn't that almost ensure a guilty verdict?
Well, you're throwing spaghetti at the wall and hoping one sticks, including the count in the indictment, but it puts a cloud over the defendant. A prosecutor loves 404B, but here's the thing, Bob, as you know, pigs get fat, hogs get slaughtered. I've had judges tell me, listen, Mr. Rossi, are you really sure you want all these other acts in? Because on appeal, it may be reversed. You may win a battle and lose the war.
Amen, Gene Rossi. I used to train my trial lawyers that way. In fact, the murder case that just recently was heard by the Supreme Court that I had tried as a prosecutor, they indicated while they were concerned about the 404 evidence because it went to motive, which is the strongest reason to use it, I was allowed to use 3 pieces of 404, but I only used 1 because I wanted the court to see that I was being judicious in the manner in which I did it and not a pile-on. And that court ultimately said, had he used all 3, we believe the defendant's right to a fair trial would have been affected. So, Gene, that's tactical lawyering. We talk about this all the time. It's not just about winning the trial. It's about surviving the appellate process. So let's go, Gene, to the arraignment real quick in one of the clips, and I'll talk to you about it on the other end.
So you're
talking to you right now, Gene Rossi, because you know what? This whole studio, Gene, it cannot deal with me and you not talking with one another. But to your point with regard to the appeal, I think that this is a problem where we see many cases like Villegas that we just handled, and a lot of the trials in 2018, prosecutors have to retry decades later because of mistakes made at the trial level. I just think that that's a bad prosecutorial tactic. Just because you can and a judge says you can doesn't mean you should.
Absolutely. There was a case, United States versus Dr. William Hurwitz. I had to try him twice, and the reason we tried him twice is I persuaded a judge to give a very good instruction on willfulness. It got to the 4th Circuit U.S. Court of Appeals. Kaboom! I had to retry him several years later. And retrials, as you know, is like putting on a wet bathing suit. It's miserable.
A wet, sandy bathing suit. Let's go to that clip on the arraignment, Gene. We'll be right back with you. All right, welcome back. So you see the defense lawyer arguing there at the end of that clip. Gene, I want to go right to this issue because I at least find it to be odd. Others are not finding it odd. You have a defense attorney that's asking to preserve information, electronic data in the case. Now, the reason I say that I find that odd is that usually as a defense lawyer, if you're going to do that, you're going to want to make sure that that information is going to be solid, good information, because you could open Pandora's box by getting something that actually harms your client. What do you think?
I think it's only a good thing for the defendant. Here's why, Bob. First off, you could have highly likely exculpatory evidence, evidence that points towards innocence for Mr. Spacey, or it attacks the credibility of potential witnesses. But let's assume that the data that you're trying to preserve or get the government to preserve of witnesses, you want to know that bad information. You want to know what is out there that could harm Mr. Spacey for a couple reasons. One, to help you prepare for trial, obviously, but what if it's such bad information and it helps the government so much, maybe it could tip the scale and have Kevin Spacey consider a guilty plea.
Oh, yeah,
so
I don't know. As a defense lawyer, I think that is a huge risk, because what I want to do is, you know, Gene, at the end of most cases, the judge reads a jury charge about the lack of evidence. You can find them not guilty based on a lack of evidence or failure to do an investigative step that they should have done. As a defense lawyer, I want to bring out on cross-examination, if I don't know what's in those records, you never got the records. You did half an investigation, and now my client has to sit here based on just the little piece of something as opposed to a whole thing. I mean, look, reasonable minds can differ, but I would not be asking for something to be preserved that could come back to hurt my client, forcing him into a plea agreement.
Well, Bob, what this tells me is they have a sense that the evidence that they're trying to preserve, in fact, does help Kevin Spacey.
Yes, agreed.
And they're willing to roll the dice. That defense attorney seemed pretty confident that information could help Kevin Spacey.
Yeah, and that's my point, Gene. I agree completely. This guy, look, I had a case one time in a murder case as a defense attorney where my guy said he didn't do it. They had fingerprints on a can, but they never analyzed the fingerprints. And before trial, he was like, I want those fingerprints analyzed. And I had to sit with him and say, are you certain? Are you 100% certain that those are not your fingerprints? Because, you know, clients can lie to you, because if they come back and they realize they made a mistake and they're your fingerprints, you are D-O-N-E, done.
Yeah, yes.
Yeah.
Yes.
So,
and that could be,
I mean, look,
that could be an ineffective assistance to counsel.
Right, and you know what? Actually, he convinced me to do it. We got the fingerprint analysis, and it wasn't him. So that goes to the point that I believe this defense lawyer knows something is in there that either, one, helps Spacey, or two, maligns the credibility of these two witnesses, and that's why he wants it. Gene, talk to us a little bit about an arraignment and what it is.
All right. An arraignment is not an initial appearance, and people get that confused. An initial appearance is when you first step into court, you don't even have an attorney, and they tell you what the charges are, and then they set a bond hearing or an arraignment. An arraignment, especially at the federal level, is when you're read the indictment or it's waived, and you're asked to plead guilty or not guilty. And if you don't plead guilty, which is rare to plead guilty, they set a trial date and a motion hearings date. That's an arraignment.
Right. All right, Gene, listen, we got more Spacey coming up and a potential for a press conference at 1:30. Don't go anywhere. We are here at the Law and Crime Network, not just with Spacey, but we got some new fascinating trials in 2019. We're going to take a break. We'll be back on the other end. Welcome back, guys. I told you we got a lot on the plate today. So we just found out here at the Law and Crime Network that the McStay family murder case, that is where 4 went missing and 3 years later found in a shallow grave. And that is a mom, a dad, and 2 preschoolers, Gianna and Joey Jr. The judge has made a ruling. He made his way to the very last minute. It was a nail biter. He is allowing live streaming from the courtroom. Amen. The public gets to see it, and we get to break it down here on the Law and Crime Network. I want to just jump back real quick, though, to Kevin Spacey. Gene, this guy, posted a really bizarre video recently that he put out into the public domain. I'm not sure if you've had an opportunity to see it. We will in a minute. But I'm curious, what do you do when you have a client that decides that I'm just going to go out into the court of public opinion and start putting stuff out there, and I'm sure the lawyers were no too happy about it?
I've had several clients like that. And here's the thing. I want to take Gorilla Tape, duct tape, and put it over their mouth. Anytime a defendant, over the advice of defense counsel, speaks, it's never a good thing.
Yeah, and you may glean information from it that can now be used against you in the court, in the trial.
Of course. Now, the clip that you probably will play of Spacey, that's a little bravado. He's trying to be cute about Frank Underwood. I wouldn't, if I were a prosecutor, I'd just stay away from it. It's stupid. But what's going to be hard during jury selection is how many people have already seen that.
Yeah, and let me ask you, even if there's nothing inculpatory about it, I forget the adjective you just used, but does it come off as smug and kind of looking at the court system in a serious situation like this in the face and not taking it seriously enough? If the jurors do get to see it, either outside the courtroom or inside the courtroom, will it make them think that this guy really thinks who the heck he is, that he's making fun of a serious situation like this?
Absolutely. I'm not sure if Bill Cosby did something like that, but he was sort of smug during both trials when he walked out of the courtroom. And I do think that eventually hurt him. And anytime a defendant acts smug, that's not a good thing.
Yeah,
period.
Smug, no good. Okay, let's take a look at that video, Gene, and let's see what we're talking about in detail, and be interested to see what you guys think online in the chat rooms about whether or not you think that this was a good idea for Kevin Spacey.
I know what you want. Oh, sure, they may have tried to separate us, but what we have is too strong. It's too powerful. I mean, after all, we shared everything, you and I. I told you my deepest, darkest secrets. I showed you exactly what people are capable of. I shocked you with my honesty, but mostly I challenged you and made you think. And you trusted me, even though you knew you shouldn't. So we're not done, no matter what anyone says. And besides, I know what you want. You want me back. Of course, some believed everything and had just been waiting with bated breath to hear me confess it all. They're just dying to have me declare that everything said is true and that I got what I deserved. Wouldn't that be easy if it was all so simple? Only you and I both know it's never that simple, not in politics and not in life. But you wouldn't believe the worst without evidence, would you? You wouldn't rush to judgments without facts, would you? Did you? No, not you. You're smarter than that. Anyway, all this presumption made for such an unsatisfying ending, and to think it could have been such a memorable send-off. I mean, if you and I have learned nothing else these past years, it's that in life and art, nothing should be off the table. We weren't afraid, not of what we said, and not of what we did, and we're still not afraid. Because I can promise you this. If I didn't pay the price for the things we both know I did do, I'm certainly not going to pay the price for the things I didn't do. Well, of course, they're going to say I'm being disrespectful, not playing by the rules, like I ever played by anyone's rules before. I never did, and you loved it. Anyhow, despite all the poppycock, the animosity, the headlines, the impeachment without a trial, despite everything, despite even my own death, I feel surprisingly good. And my confidence grows each day that soon enough you will know the full truth. Wait a minute. Now that I think of it, you never actually saw me die, did you? Conclusions can be so deceiving. Miss me?
Gene, I don't know how no matter how you cut this baby up, this is just bordering on bizarre and weird, plain and simple.
That's pathological. Bob, I got to tell you this. I said that if I were a prosecutor, I wouldn't play parts of that. I don't know. I might be at equipoise. That was deranged, arrogant, condescending behavior. I'm above the law, and I don't play by the rules. Mm-hmm. Please. And I got to tell you this. If his attorneys were in that room when he filmed that or knew about it and condoned it, shame on him.
Well, Gene, let's go to that point. I wasn't thinking of discussing this, but I think it's a really good point. It's like, what was that guy's name that went into the bathroom with the mic on and he was essentially may have confessed to a crime, not knowing that he was live. My point is that I've seen a number of quote unquote high profile celebrity lawyers who love to keep the media going, love to be in the room and letting them give interviews. I can just tell you from my standpoint, from what I do, I'm sure you do, and I know as a prosecutor, most defense lawyers do, is they lock it up. They don't want media attention. They don't want it to be the court of public opinion. They don't want it to be a spectacle. Now, I know that's good for business for the lawyer, but it always seems to me to be bad for the client. Can you think of one who ever benefited from it?
None. Zero. Period. None. Here's the thing. I just had a thought. Maybe they made the calculation that Kevin Spacey will either plead guilty or be found guilty by a judge or a jury. And they're making a calculation that he won't get jail time or get very little. That's a video that's sort of prepping for his return, his second act, the comeback kid.
Yeah,
I just thought of that.
Well, I'll tell you another thing, Gene. A lot of people think that people of high stature like Kevin Spacey, Bill Cosby, people of this nature get a bigger break in the criminal justice system. It has been my experience that once charged, it's actually harsher against them, and prosecutors want to make sure that, and judges want to make sure that it's not perceived that they're getting a break over the average guy. What's been your experience with that?
I think that courts are harder on celebrities. I do believe that. They want to send a message. But I did want to say this. Where's this case being tried? In Nantucket. All right? I've been in Nantucket. It's a beautiful island. Maybe the jury pool there, I don't know. They may have done polling, who knows, that is somewhat sympathetic relatively to the allegations, and they're not going to be accepting the government's position, without any questions. Maybe they've done some research before they did that video. I don't know.
Well, you bring up the point that it is true. I don't think the video is good anywhere, period, end of story. But where you are in a particular county can substantially change the outcome of cases. When I've used this with you before, when I was in an urban county, in Hudson County or in Essex County, you had one kind of jury pool. And when you go to a suburban county, which was predominantly white and very affluent, they were extremely conservative, and the prosecutor's job was far easier with those convictions. I mean, there's no question about that.
Oh, yeah. Well, I'm from the Eastern District of Virginia. The jury pool has changed dramatically. But 25 years ago, I would have drug dealers talking on wiretaps and on recorded calls saying, don't do any drug deals in Virginia. They actually enforce the laws and you'll get a stiff sentence. So you're absolutely right. It does depend on where you're tried.
All right. Hey, listen, Gene, always love having you on, my man. A guy who speaks from experience and very capable trial lawyer. As I indicated to you guys, the McStay family murder case where this guy, Charles Merritt, is accused of obliterating a family. We are going to be able to show a live stream of that trial, and I can't wait to get to it because this was an old case, got solved in a very unique way. There's a picture of him now. We have to run to a break. We will be back. Stay with us, and I'll be having more commentary with my man, Gene Rossi. As I said, we have breaking news here at the Law and Crime Network. The McStay family murder case where Charles Merritt is on trial for having killed an entire family. There was a 2010 case. It was at first a missing persons case. Then a motorcyclist is driving in the desert years later and sees the skeletal remains that turn out to be the McStay family. This is really, the cops were baffled by this, and they arrested Charles Merritt. At one point in time, Merritt wanted to defend himself. He wanted to go pro se, as they say, and he claims that he's only got months to live. Nevertheless, we were not sure whether the judge was going to allow this trial to be live streamed. This is a thing that I don't understand in 2019, why we all have to battle to get inside that courtroom. The proceedings are about to begin. We told you that when they do, we will be covering it live. Gene, I mean, this case is really unbelievable. It's a mom, a dad, Joseph and Summer were the parents, two preschoolers, Gianna and Joey Jr. They had to be identified by dental records, and Charles Merritt was the business partner, and they believe that that is the motive for these murders. I think it's going to be a fascinating case coming up here, and I'm just really interested as to whether or not the prosecution, or rather the defense, is going to argue you got the wrong guy.
You know, they probably could argue that. The thing about these murder cases that are old and you don't have any bodies other than dental records, that is sort of a disadvantage for the prosecution, because you can't tell how they passed away, what was done to them. All you have are dental records, I think. That's a problem. And number two, whenever it's an old case, you don't have as many records, you don't have any witnesses that I understand, and I don't know if they have DNA. I doubt they do.
So, Gene, what you have, gets to your point, is a years-old case. This biker finds, well, let me back up a little bit. At first, it was considered a missing persons case. The family was trying to get the police to go to the house to do a welfare check. They didn't see any signs of foul play. Eventually, a family member, as I understand this case, goes through the window of the family's house, finds that the dogs had not been fed for many days, and that there was food still on the kitchen table as if it hadn't been eaten. And that obviously became suspicious, and the police became suspicious. The FBI was brought in. Interpol was brought in, because at a certain point in time, they found computer records that were made to look like the mother and father may be wanting to take the kids and get them passports to go to Mexico. There was a belief that they saw a vehicle or a description of these individuals going into Mexico. So you had all these interagency things happening. But to your point, something that I found really interesting, at least to tell to me, is that on November 11, 2013, the biker finds the human remains in the desert. As you've indicated, it makes it very hard to do a very complete pathological pathology, if you will, from a forensic medical examiner. But he wasn't arrested almost until a full year later, on November 7th, 2014. That's literally a week shy of a year, or 4 days shy of a year from when the skeletal remains were recovered. It says to me that they had to really develop some motive here, that they were not 100% convinced of him as a target from the beginning, clearly.
Right, and they probably found their motive, which was some financial problem that he may have had with Joseph McStay or the Joseph McStay family. And that takes time to develop a financial case, and it seems like the motive is basically a financial case. You can't do that in 1 week. You have to get records, and you have to talk to witnesses. So that's why it probably took a year.
Well, I think it'd be really interesting to listen to the prosecution's opening here as to how they tied him in. And we are told that from my producers that the jury's actually in the courtroom right now. So the prosecution, of course, the first order of business, prosecutor is going to give their opening statement. Gene Rossi, we love to critique the attorneys in the cases, having been in the fire ourselves. We always wish them the best of luck, both the prosecution and the defense, because everyone is entitled to have a strong, hard-hitting, fair fight. That's what gets us best to the approximation of truth in a case. What do you think? I know it's kind of hard to ask you to speculate, but you know I'm a fan of defense lawyers being specific as best as they can to give the jury the idea of their defense, if they can, in the beginning. Yeah, what do you think?
I'm just going to guess that in the defense opening, I would say this. This is an older case. You have dental records. It's a horrible crime. Horrible. But all you have against my client is that he had a business relationship that wasn't going well, and therefore he's going to kill 4 people because of that. as the evidence will show, that makes no sense. And the evidence directly against my client is relatively none. They are stretching. That's what I would say.
Right. And Gene, we have so many new viewers on so many different platforms here now on the Law and Crime Network. So many have not had the opportunity to listen to me and you as we debate these issues, having been on both sides of the aisle arguing criminal cases for our entire careers. The point that I think we're trying to make here is rather than get up and just say, you have to keep an open mind and he's presumed innocent and the state has to prove the case beyond a reasonable doubt. Those are all good points to make. But you have an opportunity in the opening to form the minds of the jurors. They say, Gene, especially for prosecutors, but I agree with defense lawyers, that the opening could be the most critical place of the case because it gives the jury the understanding of when the evidence is coming in, one witness after another witness, they understand the context of how that evidence is coming in and its meaning.
And the other point I want to make, I agree with you, is I've seen so many defense attorneys get up there, and I don't mind them talking about beyond a reasonable doubt, keeping an open mind, but they seem defensive. And a defense attorney has to be aggressive relatively in their opening, and they have to build a rapport in the opening statement so that whatever comes out of your mouth has credibility.
Right.
And
Gene,
don't overpromise.
Gene, I agree with you 100%. The judge is talking. Let's just take a little peek-see in there and see what's going on. All right, so what we are looking at is the beginning of this McStay family murder case, where Charles Merritt is charged. The judge got up there and basically laid the ground rules, which are not uncommon in a case like this, i.e. I'll allow live streaming, but you're not to shoot the jurors. That always is a concern, and that is a standard thing. They are now at sidebar. Presumably we'll be starting opening statements soon. Gene, I don't know about where you've practiced, but the thing they didn't tell me when I tried my first jury trial as a prosecutor was that before you actually open, the judge gives this preamble, if you will, to the jury that could be like 15 or 20 minutes long. I was like a caged lion. I was so nervous, excited, so many different emotions going, my heart pounding. I didn't think I was like, when is this judge going to just shut up so I can start talking? Do they do that where you're at?
I actually, yes, they did. They call them preliminary jury instructions that the judge gives to the jury before openings. I like them, and here's why. I always try to incorporate in my opening 1 or 2 points that the judge said in the preliminary instructions so that I'm getting credibility because I'm quoting the judge. And I used to like that. I felt it was very effective. I enjoyed them.
Well, that's something I used to train my lawyers to do, both in the openings and the closings. We all know what the law is going to be in the closing. There's a charge conference beforehand. It's written out. The judge is typically just reading word for word and saying something that the judge is going to say. Like, it's not just, you can find him not guilty, not just based on the evidence, but the lack of evidence. And if you don't believe me, I'm pretty confident the judge will tell you the same thing. And you literally see the jurors look at you when the judge says it, as if like, yeah, that's what you said.
Exactly. And the other thing about preliminary instructions, the judge never shows you those before she or he reads it to the jury. Never.
Right. Yeah, I guess my first trial was I wasn't anticipating it. And so I just wanted to get up there. And like I said, I was really nervous. And I taught the lawyers about that afterwards. Embrace your nervousness and your fear. It'll all go away the minute you get on your feet.
Absolutely.
We're watching a court right now. I don't know if we're going to go in and, let's go see what the judge is saying, because openings have to be starting soon. Gene, the old adage, hurry up and wait. So the judge gives the preliminary instructions. He's taking a 5-minute break. We'll see whether this judge is a stickler for that, because I've been involved in trials, Gene, where they say 5 minutes and they don't come back out on the bench for 45 minutes. So it makes it very hard for a prosecutor, by the way. Let's talk a little bit about that. If you have a judge who maybe isn't that timely or is taking a lot of breaks, and as a prosecutor, you have to have all of your witnesses ready to go, and you want your witnesses in a very specific order. We're very retentive about how our case is going in. And, life is life. Sometimes witnesses can't make it. They have work commitments. They get sick. The car breaks down. And yet I've seen other lawyers, Gene Rossi, other prosecutors, you've trained 1,000 of them, who just kind of like, well, I'll just throw whatever witness on, no biggie, and it'll come together at the end, which I think is disastrous for a prosecutor to do.
Well, I trained a lot of prosecutors, and it was like herding cats at times. And there's a judge in the Eastern District, Virginia, Alexandria. I love him to death. But whenever he said, we'll take a 5-minute break, it wasn't 45 minutes, it was 50 minutes. And we used to bet an over and under. And I always won because I always estimated more time. And that is absolutely frustrating because you have witnesses teed up in the hallway and you're trying to get them out of there. And they're putting stress on you because they got to go daycare, they have work commitments, and it's added stress. So I had some judges that were punctual as heck and would literally take the bench before 9 o'clock in the morning. And others like the 50-minute person I mentioned, who's very frustrating, but I still love him.
Yes. Well, I think that we have actually a little bit of what we call a package here. I believe it's on this case from our great Rachel Stockman. So let's just take a look at that. And, Gene, as we're waiting for the judge to come back, we'll take a look at that and some other interesting what it's like to be a trial lawyer and how we prepare our cases as the show is about to go on. Let's take a look at that package.
Charles Merritt is facing murder charges for allegedly killing a family of 4 and burying their bodies in the desert. Joseph, Summer, Gianni, and Joseph McStay Jr. vanished from their Southern California home on February 4, 2010. Police found no evidence of struggle or foul play, but did identify signs that the family left in a hurry. The family car was found 4 days later abandoned at the Mexican border with no sign of the McStays. Law enforcement eventually believed the family fled to Mexico. Surveillance video at the border showed a family of 4 resembling the McStays crossing the border on foot. Officers also found search history on the family computer about travel to Mexico and passports for children. But a grisly discovery came nearly 4 years later when an off-road motorcyclist discovered the partial remains of a child's skull on the outskirts of the Mojave Desert. A search revealed 2 shallow graves containing the remains of 3 more bodies. DNA and dental records matched the bodies to that of the McStay family. A 3-pound sledgehammer was buried with the bodies. The family had been bludgeoned to death, according to prosecutors. As law enforcement was investigating the McStay's family disappearance, San Diego detectives interviewed Charles Merritt, a business partner of Joseph McStay. According to the affidavit, it was determined that Merritt was the last person to see and talk to Joseph alive. The two had met at a fast food restaurant before the family went missing. The last cell phone activity on Joseph's phone was a call to Charles Merritt. Merritt's DNA was also found on the family car abandoned at the border on the steering wheel, the gear shift, and the radio. He claimed he never driven the car, but rode in the passenger seat with Joseph 6 weeks prior to when the family went missing. Charles Merritt is pleading not guilty to the charges. Defense attorneys are pointing to another business associate as a possible suspect. Merritt is facing 4 counts of murder. For Law and Crime, I'm Rachel Stockman.
Well, thank you, Rachel. Excellent recitation of the case, the McStay family murder case. And this is where Charles Merritt, the former business partner of the father, Joseph, is on trial for their murder. And just to recap that, Joseph and his wife, Summer, and their 2 preschool children, Gianni and Joey Jr., were all killed, and that is what Mr. Merritt is on trial for. This was from back in 2010, and the kind of case went cold. As you listen to Rachel indicate there was some video where they thought that they went over crossing the border into Mexico, and also this fact, which I find very interesting, Gene, that there were searches on the computer of the McStays for getting passports for their kids to travel to Mexico around and about this time. So you have 2 pieces of evidence that are pointing towards Mexico, a video that I'm sure the defense is going to say that was them, or a search on the computer. If he does not, that is Charles Merritt, have access to that computer, could it be they were on their way and somebody else committed the murder?
Well, it supports the theory that they did go to Mexico. They intended to go to Mexico. And maybe they were killed by drug lords and eventually deposited in the desert, brutal as that is. So that's a theory that the defense could latch onto. The DNA, I thought there was no DNA at all, but the DNA on the car and him saying he never got in the driver's seat, that obviously does not help the defendant. I don't think it's something that you can't get over, but that probably is the most compelling evidence But the motive, just because they were business partners, that is not a motive for killing 4 people. That's the thing.
Right, and Gene, you know, the DNA, I agree with you. That's the strongest point that I've heard so far for the prosecution. I cannot wait for this opening statement. But
I know.
The defendant did say he was in that vehicle, and DNA can transfer. So, you know, yeah, it's not a good fact for him because it's on the steering wheel and on the stick shift, the gear shift, I guess. But, you know, nevertheless, DNA can get to places in all sorts of ways.
Right, and that's why I say it's not insurmountable. What does trouble me is he's probably one of the last people to see him, so that would be a troubling thing. And also go back to the home. You have the animals that they have, and it seems that they were taken out of the home without any preparation. They had food, I think, on the table. The animals hadn't been fed. That suggests that that trip to Mexico may have been planned by the killer. Unauthorized planning.
Yeah, so do you think that it could be a scenario where the prosecution will argue that he used their computer after he killed them or after he abducted them in order to throw off law enforcement authorities to make it look like this is really just a family that picked up and left and went to Mexico? Or could the prosecution be arguing that they were going to Mexico because they were afraid of this guy and knew that harm was going to come to him? I just, right now, we don't know. There's so many things that I can't wait to listen to come out of the prosecutor's mouth here.
I think the prosecutor's going to say in opening that there's strong circumstantial evidence that this man, this defendant, hacked their computer and planned that Mexico trip. But then you go to that photo that shows 4 people crossing the border that look like them. This has got some reasonable doubt.
Yeah, so what I understand, Gene, it's going on in the courtroom right now is one of the state's first witnesses videotaped or have that live stream on her, and that's what they were discussing there. I'm not sure what the outcome of that was, but the judge is back on the bench, and we are anticipating in the McStay family murder case where Charles Merritt is accused of killing a family of 4, that opening statement starting with the prosecution will commence shortly. And I see, Gene, they do it old school with a court reporter there.
Oh, Bob, I got to tell you, court reporters were my best friend during a trial. I always made reference to them. I smiled at them.
Absolutely.
And the juries love when attorneys respect a court reporter.
Gene, my dad, 86 years old, still practicing law, you know him, told me from the beginning, you need to cozy up immediately to the court clerk and the court reporter because they'll be your 2 best friends. And also the sheriff's officers in the courtroom as well. Everybody would think it'd be like the judge or your adversary. You know, obviously you have to deal with them, but those are the people that could do those little nips and tucks and things for you that can make your job a lot easier in that courtroom.
And don't forget the law clerks. I always try to bond with the law clerks.
Yeah, bonding is good. Bonding is good with the court staff. But so let's go into, we're getting the feedback up there in that courtroom, so it gives us a little more opportunity. When you're getting ready to prepare this case, Gene, we've been talking about trials in 2018, and I was really shocked at that. Sometimes they're capital murder cases, and they're done like in a week or less. My experience, and I don't think there's a murder case I've ever tried that's been less than a month long in terms of all of the witnesses. It just seems like a lot of witnesses go on, but there's not a lot of great lengthy examination of those witnesses. Have you found that there's a lot of brevity, and it's almost, we kind of talked about one case in particular where we said it just kind of looked like a formality that they were going through the trial?
Yeah, well, I called them slow pleas. You know, trials are each one is unique, as you know. And I got to tell you, in the Eastern District of Virginia, I tried a case. We had 50 witnesses. We did it in 2 or 3 days because the Judge Leona Brinkema, was in our face and making us being very efficient. When I hear about other districts, federal and state, where a trial in EDVA, Virginia, would be 3 days, it would probably be 6 weeks in other districts. And here's why. The judge has total control over how fast a trial can go.
It gets us, Gene, I'm sorry to cut you off. It gets us back to that point. Are you going to start at 9? Are you going to drive witness after witness after witness?
Yep.
Or are you going to be lackadaisical? That certainly can have a big impact, Gene. I'm sorry to cut you off, but we got to go to a break, and we'll be back with the McStay family murder case. Okay, welcome back, Law and Crime Network. We are looking at dealing with the McStay family murder case, Charles Merritt on trial. Unfortunately, we're having some audio problems after all the time it took for the judge to make a decision, literally to the last minute as to whether he was even going to allow a live feed in there. But I got Gene Rossi with me. We got our producers and control room people that are in the back there trying to do the magic that they do every day. So the minute that we're going to get that audio, we're going to bring it to you. And of course, in the meantime, we have other people that are tracking what's being said in there, so we'll have an opportunity to bring to you these substantive arguments that Gene and myself have been talking about, because this is a fascinating case. Gene, I want to go to something that I thought was really interesting, because our careers have spanned a period of time where the judge was telling the jury that you can take notes in this case. And we can see, again, the video there. We'll get the sound to you folks as soon as we can. You could take notes, but don't be overly distracted, because the tone of a person's voice, their facial expressions, the manner in which they handle themselves are all important, in essence, for you to evaluate their credibility. The reason I bring this out is that there was a lot of controversy when we first started. The jurors were not allowed to take notes, were not allowed to ask questions because of the concerns with distractions. And here we are today in a completely different space. And the judge notes about those facial expressions and their demeanor. You remember that trial that we covered in 2018 where they had actors up there basically reading the transcripts from decades ago? I mean, you lose all of that ability to judge the credibility of witnesses when you're just reading testimony.
Bob, I'm dating myself, but I started with the Justice Department in 1989. I remember trying cases where they didn't have notes, no notepads.
Right.
And then when they allowed notes, we're going, oh, my God, this is fantastic. And but here's the thing about notes. And the judge was great. I love this judge. He said, listen, it's okay to take notes. You don't have to. But don't be consumed by the notes, because you want to look at the facial expressions, their tone of voice, their mannerisms, because that's probably more important than their words. That's essentially what he said. That's a beautiful thing to say.
Right. I mean, people communicate in so many different words that are more powerful even than the words themselves, and the expressions and the manner in which. Remember, we were talking about the Van Dyke trial and the way that he was answering the questions and slouched over, and whether they have an angry face on or not, whether they're telling the truth or not, how they're rolling their eyes, their attitude, are all key factors to a person's, demeanor and credibility. So I've always had a problem with just reading straight testimony into the record, because you lose all that.
Oh, absolutely. I never like to read. Very few times I had somebody read a transcript, but you're right, you lose that. And I got to tell you, you've seen this, Bob. You prep a witness, you think they're going to be great, and that, they're all gung-ho, and then they get in that witness box and they see that jury, and they become Jekyll and Hyde, and they end up being a horrible witness. And I've seen the opposite. You never know.
And it goes to witness preparation. I actually defended a murder case one time, Gene, where the prosecutor didn't realize, if they had read the statement of their one of their witnesses, they would have realized the witness couldn't read or write. The statement had to be read to them. And at the end, the cop says, you don't read or write. I'm reading this statement to you as I read it accurately. And will you sign? He signed it. The reason it became important is when the kid made a mistake on the witness stand and the prosecutor tried to rehabilitate him about what he previously said. The kid didn't want to say, I can't read and write in front of the jury. And the prosecutor wound up attacking his own witness. And it was a major witness in the case, which allowed me in summation to say, can you get this? This guy calls this guy to be his witness. He's not getting the answers he doesn't like. He's trying to show him the guy's statement. The guy won't even respond to his own statement. Right. It was a not guilty.
That's beautiful. That's beautiful.
And that comes down to poor witness. So it's very clear to me in that trial, Gene, is this an experience that you've had? I think it's an uncommon one, but a lot of times witnesses are put on the stand that maybe another office member interviewed or weren't even interviewed at all.
Well, I never allowed that in my cases or people I trained, but I have seen it where, Bob, here's what happens. The witness, whether it's an officer or layperson, shows up 20 minutes before the event, the trial or the hearing, and then they're prepped on the fly, which is not enough.
Hey, Gene, I just gotta let you know, you got a compliment on Twitter by Brian Ireland, who says he loves when you and me describe how we would attack a case from both the prosecutor's and defense attorney's perspective. Great job playing devil's advocate. I responded back to him on Twitter. And by the way, if you guys ever want to follow me on Twitter, it's at Bianchi, ESQ, Bianchi, ESQ. But I responded back to him, Gene, and I'm curious to this. Yeah, we can argue both sides. That's what we're trained to do. But as a prosecutor, I would always put my defense lawyer hat on and say, what would I as a defense lawyer do? And then I'd backtrack as a prosecutor and cut those avenues of argument off.
Oh, Bob, when I used to prep law enforcement or a lay witness, I would cross-examine them. And I would do a vicious cross. Because I said to him, I go, listen, we have to know both sides of this issue, both sides of a coin. And trials are like pancakes. There are two sides. Don't think a jury's just going to buy what we say, hook, line, and sinker. You got to prepare for the worst. I used to love doing that.
Right, Gene, I would actually tell my witnesses that, listen, I'd start off with the preface. I'm going to get you really agitated here today, okay? So please, don't get mad, don't get angry, but this is what I got to do, because here's the thing. I want you to walk out of this room knowing that what you're going to get down here today, you will not get up in that courtroom. This will be more aggressive, it'll be more in your face, and by the way, you find out data and you find out information along the way that way, including how your witness will come off in front of that jury if they were to be really hammered in that courtroom.
Yeah, and Bob, we love experts, right? I used to love to cross-examine my own experts because experts think they're the smartest person in the courtroom. And when you're prepping them and you're crossing them really hard, they would take it personally. Yes. It was really bizarre.
Yeah, I think I probably told you the story about the guy who kept saying in his voir dire and direct examination how, when I graduated Harvard and then I went to, Harvard Medical School, and at Harvard they taught us, and at Harvard this, and at Harvard that. And at one point he said, I like common sense when I'm arguing against an expert. I don't want to get into too much science with them. I don't want to get in the cage with a bear. I want to be able to poke them from outside the cage. And he wouldn't, Gene, it was funny, he wouldn't agree with me that a photo I showed of him was a kitchen, right? And I was like, well, what is that thing you call over there? He's like, a stove. And what's that thing over there? That's a refrigerator. And and I went through the whole elements of a kitchen, and I said, listen, I didn't go to Harvard. I didn't go to Harvard Medical School. I'm not an Ivy League educated guy. I'm just a Seton Hall guy, Providence College guy. But within a reasonable degree of scientific certainty, sir, would we agree that that's a kitchen? Do you need to go to Harvard to figure that one out? The jury was dying laughing. But to your point, that expert was not used to being anything other than a top gun, and he was agitated and blew up on the witness stand from that point forward.
Oh yeah. But I wish we get that live feed and you can hear the voices of the openings.
Right. Yeah, unfortunately, Gene, we're working on it, so I think it'd be a good opportunity right now to go to at least the McStay family murder package from Rachel Stockman, so we can at least give our audience an idea of what this horrible, horrific, yet it's going to be a very interesting trial is all about.
Charles Merritt is facing murder charges for allegedly killing a family of 4 and burying their bodies in the desert. Joseph, Summer, Gianni, and Joseph McStay Jr. vanished from their Southern California home on February 4, 2010. Police found no evidence of struggle or foul play, but did identify signs that the family left in a hurry. The family car was found 4 days later abandoned at the Mexican border with no sign of the McStays. Law enforcement eventually believed the family fled to Mexico. Surveillance video at the border showed a family of 4 resembling the McStays crossing the border on foot. Officers also found search history on the family computer about travel to Mexico and passports for children. But a grisly discovery came nearly 4 years later when an off-road motorcyclist discovered the partial remains of a child's skull on the outskirts of the Mojave Desert. A search revealed 2 shallow graves containing the remains of 3 more bodies. DNA and dental records matched the bodies to that of the McStay family. A 3-pound sledgehammer was buried with the bodies. The family had been bludgeoned to death, according to prosecutors. As law enforcement was investigating the McStay's family disappearance, San Diego detectives interviewed Charles Merritt, a business partner of Joseph McStay. According to the affidavit, it was determined that Merritt was the last person to see and talk to Joseph alive. The two had met at a fast food restaurant before the family went missing. The last cell phone activity on Joseph's phone was a call to Charles Merritt. Merritt's DNA was also found on the family car abandoned at the border on the steering wheel, the gear shift, and the radio. He claimed he never driven the car, but rode in the passenger seat with Joseph 6 weeks prior to when the family went missing. Charles Merritt is pleading not guilty to the charges. Defense attorneys are pointing to another business associate as a possible suspect. Merritt is facing 4 counts of murder. For Law and Crime, I'm Rachel Stockman.
All right, welcome back. So we're in the McStay family murder case. Charles Merritt on trial for the murder of an entire family, a mom, a dad, and 2 preschoolers. I have Gene Rossi with me. Gene, the typical law in most cases is that the prosecutor's opening statement, and we're still trying to work on getting that audio on the live stream, they have to lay out each and every element of the offenses that are charged in the indictment, because if they don't, at the end of that, the defense can move to actually have a charge technically thrown out because the prosecution didn't open to it. Now, I've never seen that happen. I've seen the argument made, but I've seen the judge allow the prosecution to reopen. I just think it's a little interesting nuance we probably never talked about on the show before.
You mean after the government rests, it's brought to their attention that they didn't prove all the elements, and then they asked to reopen?
Yes.
Is that your question?
Have you ever seen that?
That happened to me once in EDVA, Alexandria. It went up on appeal, and the court granted a new trial because the court felt that the judge had abused discretion in allowing us to reopen. And but it goes back to this: we were embarrassed because we missed an element of the crime. It was pretty pathetic. But you live and learn. Yeah,
wow, that's amazing, Gene. Thanks so much. Okay, guys, listen, we're going to go to a quick break. We're going to come back on the other end. I'll either have more Gene Rossi, the McStay trial. We'll talk about it, break it down with you. We got a lot of interesting things going on, so stick with us. We're going to get that audio up and running. Welcome back to the Law and Crime Network. We're going to try to get that feed in the McStay trial straight away from you, but we will definitely have a recap of everything that's being said, so don't worry about that. But we got so much going on. We're going to switch gears a little bit to Michigan versus Jason Dalton. Gene, this is a 6-count homicide case. There's the defendant there on your screen. 2 survived the shooting spree. This is bizarre, bizarre, bizarre. There you see the victims right there. There they are. And I always said this as a prosecutor. They woke up that day, and none of them expected that the carnage was about to occur. This guy's like an Uber driver, something about a devil in his phone, and he's you know, things telling him to do certain things. He passes by a girl, Tiana Carruthers, and basically asks her if she's this McKinney person, and she says no, and he drives around and about, and eventually comes back and shoots and wounds Carruthers. She actually lives. And he then is going back and forth to doing Uber and going to his parents' home, and then he goes back to a car dealership where he shoots a father and a son, and then winds up again tooling around, picking up fares. Can you imagine this? I mean, all those people that were taking fares in the days that this guy was committing these murders, they themselves could have been victims. And then he winds up at a Cracker Barrel where he winds up shooting and killing a number of people, including shooting a 14-year-old who also survived. She's one of the 2 that survived. In all, there were 6 homicide counts, 2, like I said, that had survived. There was a motion to see whether he was competent to stand trial. The court found that he was competent to stand trial. However, statements that he made to the police were suppressed because the court argued that his right to remain silent was not, quote, scrupulously honored. That is actually a legal term that's used. And there was an indication in the articles that I read that he had in some way either equivocated or invoked his right to remain silent approximately 40 times in 3 hours. Gene, I want to, we had a major development in this case today, a shocker for us as we were getting ready to prepare this case gavel to gavel like we are the other ones. I'm not sure if you're aware of it, but against the advice of his attorney, Dalton chose to plead guilty today to all of those counts. We have some fascinating, and I want to talk to you about this on the other end. When a lawyer and a client are not on the same page, especially when you're telling them not to plead guilty and they are pleading guilty to basically the rest of their life in jail. Let's take a look.
Discussions of plea offers have been going on between my client and I for months since this case has been pending, and I've spent an hour and a half with my client, Mr. Dalton, this past weekend. And I've discussed the pros and cons of a potential plea, especially as charged. That's what's being done today. He understands those consequences. He is doing that against my advice. But in speaking to Mr. Dalton, there are reasons for that. There are personal reasons to him. He does not want to put his family through that, or the victims' families through the trial. So it's his decision against my advice, but I obviously will have to.
Gene, I'm just going to throw it to you. What do you think of that? I mean, certainly not a position as a defense lawyer you want to be in to, there's client confidentiality issues, but by the same time, you got to protect the record. I wouldn't want to be in that position as a defense lawyer.
Well, here's what people need to know, your audiences. When you have a guilty plea hearing under Federal Rule of Evidence 11, and I'm sure the states have the same rule, statements made during those proceedings can never be used in a trial, and an attorney is allowed to talk about the advice and give a summary of what they told the client. I got to say this, in my almost 30 years, I never had a defense attorney say, my client wants to plead guilty, but I told that person not to plead guilty, which tells me this. The defense attorney probably has strong evidence that he was insane at the time he committed the crime. He may be competent now, but at that time he was insane. And that's probably what he's getting at.
Right, so that's a great discussion to just emphasize, because people often get this confused. Competency is whether you can assist your attorney during the course of the trial, whereas not guilty by reason of his insanity is at the time that the acts were committed. And we're talking about devils and phones and this craziness going on, and that the person was not able to appreciate generally the rightfulness or wrongfulness of their conduct, and that could result in a not guilty by reason of insanity. I think the other piece to add to your point, Gene, is that the lawyer is saying he's just pleading guilty to spare, if I heard this correctly, the victim's family,
yeah.
And I've had clients that have said this, spare them the trauma of the trial. But the defense lawyer is probably saying, why just give it to them? Let them take it away. I've got this insanity argument I can at least make, and maybe it works, maybe it doesn't, but you just basically pled your life away.
Absolutely, and I don't think he pleaded guilty in exchange for dropping the death penalty. I don't think that was the deal. I don't think they were. Okay, I could be wrong, Bob.
Gene Rossi, we're all over. We have sound in McStay. Let's get to it. Prosecution's opening in the McStay case. We are deeply, deeply sorry that we weren't able to get that audio for you, but we will definitely have a recap for you. We're going to go to a quick break, and then we're going to come back with that Dalton press conference that should be starting soon. Fascinating case as well. Stay with us. We have our second breaking news today, and that is with regard to this Dalton case. Jason Dalton, the state of Michigan brought 6 homicide counts against him, as well as 2 people who were shot and actually survived a rampage by, obviously, this is not a strict legal definition, a maniac. We saw one clip already where the lawyer got up there and said, against my advice, the defendant wants to plead guilty today. He pled guilty to those murders without the benefit of a plea bargain. We got a press conference going on. Let's go to it.
So in that grave was a black backpack. And one of the boys always wore a black.
You know, Mama told me there'd be days like this, Gene Rossi. So, guys, But listen, better to talk about the case. You know, we could always read about the press conference. We're going to get the update on it as it's happening. So, Gene, the lawyer got upset. He did it against my advice. We already discussed the idea that why just plead guilty to these things? There's an insanity defense clearly that's in this case. These guys are devils, and he's going around in his Uber. He thinks people are certain people. He's shooting randomly. But instead, by pleading guilty, he indicated he wanted to spare the victim's family of the trauma of going through a trial. I've only had one defendant in my entire career that basically said the same thing to me and was willing to accept the plea offer in that case in order just to spare the victim's family, and was actually very remorseful and believed he should do the time. Well, have you ever had anything like that yourself, Gene?
No, I have not. And the other thing I wanted to add this, when they go through the guilty plea colloquy, the judge and the defendant, Mr. Dalton, they ask him, are you pleading guilty because you are in fact guilty? And they also asked, have you consulted with your attorney? And oftentimes the defendant will relay what the attorney told him. I got to tell you, if he's pleading guilty, even though he thinks he's innocent, that could cause some problems on appeal if this is ever appealed. So, you know, helping keep the victims from suffering from all the trauma of a trial is not a reason for a defendant to accept responsibility legally. That's not a valid reason.
Right. I think, though, from what I reviewed when I saw the plea going through earlier this morning, though, Gene, is the prosecutor did a really good job at going through each of those murders and saying you did it and you did it purposefully and it was premeditated, i.e. before you pulled the trigger, you intended to kill those individuals. He had a kind of weird look on his face when he said yes, but he said the words. The judge found that he was competent, that he wasn't being threatened or forced or coerced. Those are the typical things a court would ask. They found that he is competent mentally to make the decision. But the prosecutor, I think, to your point, was very, very careful to make sure that he pled to each specific count, saying that it was purposeful, premeditated murder, which the defendant said it was. So I think it kind of ameliorates that issue that he's trying to spare the victim's family was the only basis for the plea.
Well, here's the problem I have with this plea is he is competent today, pleading guilty. But how can you possibly say I'm guilty when there could be possibly strong evidence that at the time you committed the crime, you weren't playing with all the decks in right. Pack of cards.
So your point, Gene, is you could be competent now, but you still could have been legally insane at the time. Let's go to that press conference.
Yeah.
All right, welcome back, guys. I love you hanging in there with us as we're having so many audio and visual problems from inside that courtroom. Our producers will let us know we can get it kind of back up. Gene, we listening to the brutality, actually, at one point, I'm not sure if our audience got to hear it, it was during a break, of finding the skeletal remains of the individual. They believe they all suffered blunt force trauma. We couldn't see the pictures themselves, but it appeared the jury was actually looking at the skeletal remains, which will obviously be moving. And now we're talking about this victim's cell phone being used to call QuickBooks to have an account deleted. So you see them tying in this financial motive. Obviously, they're going to tie in that that person that was doing that was either the defendant, Merritt, or on Merritt's behalf. What are your thoughts so far?
The cell phone calls to QuickBooks and all this circumstantial evidence, the backdating of the 4 checks, that is incredibly powerful, and it adds credence to the DNA. If all they had was the DNA on the radio and driver's wheel, that would be problematic. But when you have backdating of checks and him calling the QuickBooks, that's powerful evidence. Oh, my goodness.
Right. And, Gene, we're not going to, we'll certainly recap everything that came out, and I'm sure at some point in time later on we'll be able to give our audience the full breadth of what the prosecution's saying. But while you can't do this quantitatively necessarily, you see this as a very laboriously long and detailed opening statement. And I say that juxtaposed to some cases we covered in 2018, where I think we both were in shock. I think there was one opening statement that was less than 5 minutes long. And again, as a prosecutor, I want to keep them entertained. I know that off camera we were a little concerned that, you know, this is a picture of this is a picture of that, this is a picture of this is a picture of that, and there wasn't much context to it. But that said, putting all the building blocks in front of the jury right now, even though it may have been a little laborious than it needed to be, is what I'm talking about, so that when the witnesses get on the stand, the jury, I get that. I understand what those checks mean. Oh, I understand the QuickBooks thing because he detailed it in this opening statement.
Oh, no, I give kudos to the prosecutor for putting that all in front of the jury in the opening. My style is thematic, where you have a theme and you explain the exhibits that you're going to show eventually to the jury. But one thing I try to avoid is show an exhibit in opening and say, please listen carefully to the testimony about this exhibit, and then you move on to another exhibit. You never should do that, and that's one of my major critiques about the opening. But he did a good job. It was laborious at times, and it's still going on, by the way.
Yeah, and again, I think that we're saying it was well done. It's giving the jury what it needs for context. It may be a little too quick to say it's a picture of this, a picture of that, picture of the other thing. That could be a minor critique in light of the fact that it's really about substance, and he is delivering, you know, that substance in some detail there. Because as a prosecutor, the number one thing you want to do when you come out of that opening statement is certainly have the jury saying, "Oh my God, there's a tremendous amount of evidence against the guy." Now, of course, the defense still has to go, and witnesses still have to take the stand, and the judge gives the instruction, as he did in this case, that anything that's said in openings and closings by the attorney is not evidence. But it shows you the paramount importance of laying the entire prosecution case to bear, so that the jury really comes away saying, wow, there looks like, if the prosecution puts all this on, a lot of evidence here.
Yes, and I got to compliment the prosecutor. I rarely see prosecutors play tapes in opening. And I thought him playing some of those tapes, key tapes, that was an excellent part of his opening, to play the tapes.
Yeah, I agree with you. I mean, like, we know this. Demonstrative evidence is important, and if you can incorporate as many of the senses as you can there, in your instance that you're giving is an audio as well as visual. But, you know, Gene, we've talked about this before, too. You know, when you have a PowerPoint presentation like this, sometimes the presentation can overcome, you know, the opening, because you're kind of tied to it, because you've got to go ad seriatim from one slide to the next. So you've got to really have that nailed down. Personally, I would use far less of those visuals, because I kind of feel my way. It's hard to explain in an opening and a closing. I have an idea where I want to go. I have an idea definitely of where I want the case to be. But I kind of feel what's happening in that courtroom and how the jurors are responding to me. For example, what do you do if a jury sits there and starts falling asleep when all these slides are being presented? You're kind of stuck with what you put together.
I had a trial. I don't like PowerPoint. I have never used PowerPoint ever in an opening, closing, or rebuttal. And here's why. Juries never fall asleep when I'm talking to them. Trust me, okay? And I had one case where the defense attorney literally caused the juror to sleep. And in my rebuttal, I started talking about polenta. It was the day before Thanksgiving. And that juror that was sleeping, he woke up and he was listening to my polenta story. It was beautiful.
I know you're a big fan of the polenta. I didn't know that you were incorporating it into your arguments in the courtroom, Gene Rossi. Hey, listen, I'm told that the prosecution opening is complete in the McStay family murder case, where Charles Merritt is on trial. So they're on a break right now. So we're going on a break right now. We'll be right back. Stick with us. All right, welcome back. So we're in this Monell trial. It is out of the great state of New Jersey. And essentially, Gene, what we're listening to the prosecutor say, and I think that this is very powerful witness, is that the little girl, I believe she was 12 at the time, is confronted and where's mom, and makes the comment, mommy's dead, daddy killed her. Now, The reason I say this is powerful is out of the mouth of babes, right? This is a 12-year-old, doesn't have an opportunity to fabricate something like this. The person almost doesn't believe what's being said, and the kid repeats it again. So this obviously is a very, very powerful statement that the prosecution is going to introduce both through the person that listened to it, the adult, as well as, it'll be interesting to see, I don't know yet, maybe our producers do, and they'll let me know, if the 12-year-old girl is going to testify, which is really a tough prosecution piece to this because mom is gone and now dad's on trial. You got to look at it from the standpoint of this child.
Absolutely. Now, this gets into evidence that statement, if she doesn't take the stand, it's either non-hearsay or it's a exception to the hearsay rule. I don't know if it is an exception. But a young person, I've called young witnesses. I think the youngest I've called was 16. They are always delicate witnesses, and they're difficult to prepare for trial because you can't do what you normally do, a practice cross, because you don't want to destroy your witness because they're so vulnerable. But I've never seen or had a 12-year-old witness, but I can imagine that will be a very difficult person for the prosecution.
You know,
and nothing against the witness.
Yeah, I'll tell you, Gene, I had to, in a death penalty case, put I believe she was like 10-year-old daughter on the stand. Her mother was killed and had to testify against her stepfather. And it was difficult to do, but she was an eyewitness to a lot of what went on. She was a crucial witness. And it broke my heart. And many, many years later, when I became the head county prosecutor, she actually called me up and congratulated me and wanted to come by and say hello because apparently the encounters that we had, she said, you were so kind to me. And you know, you winked at me one time in the middle of the trial when you knew I was nervous and upset. And she actually got into the field of like the criminal justice world because of that experience. But, you know, I always wondered, you know, in one fell swoop, she lost, you know, everything. She wound up with her maternal grandparents at the end of the day. But, you know, you put them on the stand and you don't like doing it. And I'll tell you something that's interesting about that. The defense attorney was so brutal to her. It was clear this kid wasn't lying. And at one point in time, he actually put the murder weapon like right in front of her on the witness stand. And the deer in the headlights look at this poor little girl. We jumped up, of course, went to sidebar, but I thought it was very unartful to attack her that way. The jury was in tears when she was testifying.
Well, that defense attorney needs to take another course in how win friends and influence people because, you know, there's destructive cross and there's constructive cross. And with a vulnerable victim like a 12-year-old or somewhat younger, you do constructive cross because you can be polite but still get out your points.
Yeah, I didn't even think there was a point to get out. The argument should have been, in my mind, it was a manslaughter and nothing that the girl, if I were the defense attorney, and nothing that the girl did went to what his state of mind was or wasn't, so it was just kind of wasted. Sometimes lawyers feel they need to just be on one speed all the time and hammer every witness, and I know me and you teach them you got to be more nimble than that. Let's listen to a little bit more, though, of the prosecution's opening, Gene. Okay, we are in the great state of New Jersey versus Jeremiah, in this, Monell in this case. Gene, what we heard the prosecutor in the opening statement, I don't know, maybe just because I love Jersey, but it doesn't have to be flashy. It doesn't have to be yelling and screaming. Everybody's technique is a little different. I think me and you probably a little more motive, but this guy is laying down the case, and he's doing just what we talked about before. And I especially liked the use of his adjectives, the power of the adjective to the jury. Face was splattered with blood, gaping wound, carpet soaked in blood, box saturated in blood. He talks about 2 knives that were found behind the stove. Jeans were bloody. And the detective speaks to the young Jeremiah and what he saw, and he saw his father choking his mom, saw the father stab her again and again, over and over. And then he lists each of the witnesses and what they're going to testify to. The crime scene witness, the DNA witness, and moreover, on one of those knives is the print of the defendant as well as the DNA of the victim's blood on the blade. What I'm seeing here, Gene, you may disagree, maybe I'm biased because it's from the great state of New Jersey, that I am seeing a prosecutor lay down the tracks for guilty.
You know what's great is like Baskin-Robbins, there are over 30 ways to do an opening. We saw the case in California. He did a solid opening, used a lot of PowerPoint. Then we have your Jersey guy. Okay, he's got the old-fashioned notepad.
Yeah, amen.
He's got it on the witness stand. No fancy lectern. And he walks up to it, flips the page. He didn't use one exhibit. Okay, he didn't even use photos of the crime scene where she was killed. But his words, you brought up a great point. His words painted the mosaic. And that's why I love trial work. He painted the mosaic with his words.
Listen, Gene, this is how we do it in Jersey. We're not playing games here with fancy computers and whatever. We are in your face with the old school legal pad. He only went to it once just to make sure, I think, to check on who the next witness was. You know what? Me too. That's how we do it. And you know what? The jury's attention is fully on him. It's not distracted. It's not looking at different things. They're all focused on him. His words are painting the picture, and he will follow up with pictures and gruesome things. I love his style. Hashtag Jersey prosecutors doing it right. Gene, we talk about style a lot, but I'm going to get back to the same point since you made the comparison that when you've got that PowerPoint up there and you're flipping around from screen to screen, I don't think you do as I'm not saying that job wasn't done well. I'm just saying that sometimes the technology can stand in the way, and I think we have a great juxtaposition with this guy doing it completely differently.
Absolutely, and both styles are effective. It's just I rarely heard a person say after an opening and closing a rebuttal, "Hey, Gene, your PowerPoint was great." If I ever heard that, I'd say, well, what about what I said? Okay?
Yeah.
I mean, I don't want you to tell me I had a great PowerPoint. I want you to say I did a great opening, closing, or rebuttal. Talk about polenta.
Hey, listen, it's those examples, those human experiences. You're making contact with that jury. You're building a relationship with that jury. It's about a personal connection with that jury. It's not antiseptic. I know you know how to do that, Gene. But listen, we got so much going on here. We're going to go back to McStay and the defense opening statement right after the break. All right, welcome back. So what we're listening to, I believe, if you've been listening to myself and my great guest, Gene Rossi, is a very detailed defense opening statement. He is doing exactly what we talked about before in giving the jury something to grab onto that could be a problem with the prosecution's theory of the case. Most notable are all the experts that they've committed that may testify, including crime scene experts, DNA, cell phone tower, forensic accountants, which the state didn't get but then got when they got it, computer forensic. We want justice for them as well. He's saying that the prosecution had confirmation bias from the beginning, disregarded the facts that didn't fit their theory. Guys, I've seen that personally myself in the investigation and prosecution of murder cases. I want to thank you so much for being with us. And Gene Rossi, I want to thank you so much. You can find me at Bianchi ESQ on Twitter or on YouTube. Subscribe to Bianchi Law Talk as well as Rossi for VA. We'll see you on Wednesday with more Law and Crime.